Hey everyone, Harry here to talk about the big DC Circuit opinion on immunity. Top line, emphatic, categorical, unanimous, really everything one might have wanted to reject and put a stake in the heart of Trump's various efforts to assert immunity. So it really methodically marches through all he argued. It goes through the various lines of inquiry that the different judges probed at oral argument. And at every turn, Trump is not just rejected, but emphatically rejected for basic issues of constitutional law. That's point one. Point two, to add even a little extra oomph, they decided that it would be per curiam. Per curiam is something akin to a unanimous opinion, but a unanimous opinion would have been written by one or the other of the judges, probably Judge Henderson. And some of the most important Supreme Court opinions, DC Circuit opinions, are written per curiam, which means there's the court is really speaking as one voice. There's a majority. If there's a unanimous opinion, but with certain turns of phrase or things that are characteristic of a chief justice, say, you identify it with that chief justice. Here, the court, which has young judges, old judges, Democrat appointed judges, Republican appointed judges, were coalescing and saying, we speak as one. That gives extra oomph. Third kind of headline is the stay and the mandate. Typically, there's a whole long process after a court of appeals rules where someone can take 30 days to ask the court as a whole to revisit the question, then 45 days to ask the Supreme Court to take cert, etc. Here they have foiled that with a very short timeline, 6 days until the mandate issues, which is basically what makes final the rule, the actual practical effect of the opinion. What does that mean? That means if Trump doesn't move by February 12th for a stay, the mandate will issue and it just goes back to Judge Chutkan, and the whole interval that we've been counting the days of ends. And so we just resume the clock as we were, having lost about 35 days or so. Now, that's not going to happen. Trump is going to move for a stay. He does not have time, it seems to me, nor good prospects for moving for a stay by asking the entire court of the DC Circuit. The way this has been written and the different judges on it, I think, make it unlikely in the extreme that he would get a stay from the broader DC Circuit. And that leaves the Supreme Court, and that gives them until Monday to apply to the Supreme Court. Now, whether or not the Supreme Court grants the stay, the circuit justice, in this case, Chief Judge Roberts is the circuit justice for the DC Circuit, will grant a temporary stay so the court will be able to consider the motion for a broader stay, the broader motion for a stay, and they'll probably make quick work of that decision. And then we're at the sort of crossroads where either they take the case, and then I think even on a fast schedule, they probably don't decide it until June, end of June, early July, and things return to Chutkan then mid-July, and we start where we had left off things in, before the oral argument. So basically at the beginning of the year, or they deny cert and they say, we're not going to disturb the DC Circuit's thorough opinion of first impression. And then that's it. As soon as they do that, might be as soon as, say, February 19th, a week after February 12th, then this little interim is over. And as I've said before, there's not another one in the wings. That is, this was his big shot to have a claim that would automatically provide him a delay based on the principle that the immunity claim is a right not to go to trial, and therefore is something that freezes the proceedings below. This was his big shot. Now, as he gets rulings against him in Chutkin, and when he gets them, I don't want to get too far ahead because, as I say, there's two possible dates here. It will just keep going forward, and he'll have to bring any appeals after a conviction if there is one. Finally, an important wrinkle in the Supreme Court, the difference between the rule of 4 and the rule of 5. So the Supreme Court takes 4 votes to grant cert, but 5 votes to grant a stay. And that means Trump's going to need 5 votes to actually keep the mandate from issuing. That's staying the proceedings. They could take the issue up and go through it and decide it, but still let things proceed in Chutkin's court. So that's a third interesting path that could ensue from Supreme Court review. All right, so those are the big takeaway items, the emphaticness of the opinion, that what it means that it's per curiam, what they're doing with the mandate in 6 days, what happens at the Supreme Court. So those are the sort of big framing of the opinion. The opinion itself is also important for what it says, and I'm going to do another YouTube right after this, going through the opinion in some detail. But I wanted first to lay out the big headlines of the overall decision. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.